Can I put TOD, transfer on death, or beneficiaries on all my accounts and put only the house in trust? Will that save the cost of a trust? So let's take these up one at a time. The first question being, can I put the TOD or transfer on death, also sometimes POD, payable on death, or beneficiaries on all of my accounts except for the house? You can, sure. Most accounts are going to allow you to either list a direct beneficiary or a POD, payable on death recipient, or a TOD, transfer on death recipient. And this is a way to avoid probate in addition to a trust. So if you name a direct beneficiary or somebody who's going to take the asset after you pass away as a POD or a TOD, that should avoid the probate process. However, I've talked about this in other videos. This isn't always the case, meaning that I have seen this in my practice several times where someone lists a POD or a TOD and they end up passing away first. If they pass away first, you're right back to probate. That asset has to go through probate. Or if you list a beneficiary or a TOD or a POD on an account and that beneficiary ends up needing government assistance such as Medicaid or supplemental Social Security income, and they inherit these assets directly, the assets become theirs, meaning they're free of trust, they're theirs outright, then that means they're going to lose their government benefits, which could be really detrimental. So depending on the scenario, it's not always wise to list a direct or an individual beneficiary. Another scenario would be a minor. You don't want to list a minor as a beneficiary on most accounts. So there's reasons that even if you're able to name a beneficiary, you might want to name your trust as the POD, TOD, or the beneficiary. But assuming, it's a safe bet to list an individual, or oftentimes with retirement accounts, this is where we really look at naming a beneficiary, an individual beneficiary, rather than the trust. Retirement accounts like 401ks, IRAs have a little bit of different rules. First of all, if you have a 401k, it's going, and you're married, it's going to go to your spouse. Regardless, that's who has precedence in taking over the 401k. But even accounts like IRAs, depending on how they were set up tax-wise, if you list the trust as a beneficiary, it oftentimes means that the entire account has to be liquidated, so much higher tax consequences versus listing individual beneficiaries. So there are accounts out there that it is sometimes better to list a POD or a TOD or a beneficiary, but these are things that should be carefully discussed with your attorney or a tax professional before simply doing it, or maybe just keeping a POD or a TOD because you had it that way before you had a trust. So answer the question, you can do it, should avoid probate, but it's not without its problems. So make sure you talk to a professional about listing a TOD or a POD rather than putting certain assets in your trust or listing the trust as the beneficiary or the POD, TOD. The next question is, will that save the cost of the trust? Probably not. So in this scenario, we're talking about putting only a house into a trust. The trust agreement still needs to be drafted or created in order to make sure that your house can go into the trust. So most likely it's relatively the same amount of work for the attorney who's drafting it. Also, oftentimes we see this where people might start with just their house in a trust and then decide later on they want to put other assets into the trust. So I really don't think that going into it with saying, I'm going to leave all my other assets out, just put a trust in. That's not really going to cut down the preparation or the drafting time for the trust itself, as the drafting of the trust is most likely going to be relatively the same amount of work. So I wouldn't count on it cutting down the cost. Probably what you're thinking with is after the trust is formed, there's this process of what we call funding the trust, which means you're taking assets that are owned in your name individually and you're retitling them under the trust, making the trust the owner so they avoid probate, or you're listing the trust as the beneficiary. Oftentimes, this is like part 2 of getting your trust plan in place, where first you have the attorney prepare the trust agreement, you sign the agreement, and then once it's signed and in place, you have to actually move these things over, fund the trust. Now, if you have beneficiaries listed on pretty much every other account, or a TOD, POD on all these accounts, then sure, you probably could save some money in this trust funding phase because the attorney would only need to assist with the deed for the house. So there would be less accounts the attorney would need to work with and to move over into the trust. But oftentimes, many of these things besides the house, you're able to do yourself anyway. So again, I wouldn't necessarily say that you're definitely going to cut down on cost. All right, so I hope this answers the question. And if you're in Florida, you have any other questions like this related to transfer on death, payable on death, or beneficiary designations, or anything to do with estate planning or elder law or probate, don't hesitate to contact our office. We're in Clearwater, and the link is in my bio.